Folks, we're back. This is Steve Sanson, Stephanie Phillips with another episode of Veterans in Politics. This is our second program for tonight. Tonight we have Margaret Pickard, Clark County District Court Judge, Family Division, Department V for victory. But before we get to Judge Pickard, Ms. Phillips.
Thanks for joining us, everybody, and thank you to our sponsors. We have Semper Fi Heating and Cooling. If you need your system checked, get in touch with them. Their website is callsemperfi.com. callsemperfi.com. We also have Henderson's mayor, Michelle Romero. She's running for re-election. Her website is votemichelleromero.com, votemichelleromero.com. Get in touch with her. Also, we have Cody K. Whipple. He is running for Congressional District 4. His website is codykforcongress.com, and that's the number 4, codykforcongress.com. Jump on his website and check out his platform. Also, don't forget to grab your copy of Steve's book, How to Navigate Nevada's Family Court System. If you are a litigant in family court and you don't have an attorney or can't afford one, this is a self-help book. You can get it on Amazon for $14.99. It will help you navigate that system. Also, we have a merch store. It's vipimerch.com, vipimerch.com. We have all kinds of fun stuff for you to check out there. And also, don't forget to grab your tickets to the Valentine's Ball. They are on sale for $99. Never sold them that low before, and they are only at that price until August 31st. So a few more days after that, the price goes up. You can also get a vendor table if you want to advertise your business, your campaign or nonprofit, and also advertise your logo on our event program. So make sure to jump on that link for the ball tickets and check out all of that stuff. For my rant, gosh, guys, some of these judges and the decisions that they make this week, we had, or was last week, Tiara Jones ordered probation for the 16-year-old Lincoln Peterson, I think his name was, going from memory, for killing his dad. Just probation. I thought that was extreme, and they were fighting about his dad took away his phone apparently, and he shot him. So anyway, I think that was sets a terrible precedent. Also, Judge Christy Craig orders probation for the gorilla pimp. Gary Guyman is his name. He's an attorney here. He refers to himself as the gorilla pimp. He agreed to a plea deal, and he was in court for what started as a sex trafficking case with an alleged murder for hire plot. Guyman entered a no contest plea to felony charges, including bribing or intimidating a witness to influence testimony and coercion. Guyman also agreed to permanent disbarment. Well, I would hope so. So all the judge gave him was probation and go see a mental, counselor. Anyway, you know what I mean. What is what I'm trying to say? I forget.
Psychiatrist, psychologist,
yeah, something
therapist.
like that. Yeah, he's having mental challenges, mental health challenges. So Guyman initially faced sex trafficking, conspiracy to commit murder, solicitation to commit murder, pandering and bribing or intimidating a witness to influence testimony. Las Vegas Metro Police said Guyman forced women he represented to perform sexual acts on him and his friends, and in one case orchestrated a murder for hire plot. In the text messages that the police obtained, because they were monitoring his communication, Guyman says, "Call me your mother effing pimp." And he says, "Offer any resistance and I just might smash your effing teeth out of your mouth." Police began their investigation in November, identified 4 victims. And also, Guyman refers to himself as the demon of validation. According to the police, Guyman forced one woman to use a sex toy and threatened her with incarceration if she did not follow his orders. Guyman, according to police, Guyman purchased a Range Rover and leased an apartment for another woman who said the relationship moved from attorney-client to romantic. And he sent numerous threatening text messages, police said. Here's another one. Guyman says, I quote, "I just became your mother effing gorilla pimp," Guyman texted. "Effective immediately, you will do what I tell you to do. You will date who I tell you to date. You will not break stride. You will march forward," in a text message to one of these women. The arrest report noted the gorilla pimp refers to a pimp who is known to be physically violent towards his prostitutes. Also, "You will suck my bleep when I tell you to. You will wear what I tell you to wear. You will speak when I tell you to speak, and you will be better off. So will your daughter." I'm reading all of these. These are very graphic, but I want you to understand what kind of criminal and person that we're dealing with that Judge Christy Craig ordered probation to. I think this is a terrible precedent. Both of these judges, I believe, it's shameful what they ordered in both of these cases. So I'll close that for now, but
Well, I like to piggyback on that. Attorneys are supposed to be officers of the court, so therefore they should be held to a higher standard,
one would think,
than the regular public,
right?
Not a lower standard.
One would think.
Yeah.
So anybody else, if that were you or I that did what he did, we would already be in prison and we would be there for many, many years. Yeah, that I don't think would ever happen to the average citizen. But, some protect their own.
Yeah. Anyways. Are you done? Are you done?
No, I'm good. I'm done.
Just figured.
Hello. How are you? Thanks for having me.
Thank you so much for coming on the program.
Absolutely.
Could you give us a bio?
A little bio. Well, I grew up in Richmond, California. I was born and raised there, and my father still lives there. After I graduated from JF Kennedy High School, I went to UC Davis. I got my degree in sociology, studying family systems, understanding why families work and why families don't in sociology. And then from there, I went to law school almost immediately at the same school. And I just developed a love for families. And from there, I ended up, after law school, going up to working for Judge Walter Carpenetti in Alaska for a little while. And it is cold in Alaska and it's frozen. So when you walk, you have to wear cleats in the wintertime. People don't realize that. And then I went to Montana for a couple of years. I practiced law there, general practice, and I loved it. I was married to a cowboy at the time. And so I loved it. It was a great place to be. And then I came here to Las Vegas. I taught up there at the university for a while, came here, taught at UNLV. And in that process, I just learned about the needs for the family courts to train parents about conflict and what that does to their kids. And so I got involved with that and trained over 1,500 parents who were ordered by the family court to learn about conflict, what they could do to reduce conflict so they weren't what we call frequent flyers in the family court system. And then from there, I started working in a mediation practice, arbitration, and I have since then, my husband and I, Keith worked in the recovery community for many years. And from that, I was asked to oversee as pro tem the juvenile drug court program, which I loved. I loved working in the recovery community. And from there, I then was appointed as a hearing master for Judge Boy. And I did that for several years in juvenile delinquency. And then I got my current appointment in 2018 to the dependency bench. And then when the position opened up as a judicial position in 2020, I ran. And so I've been doing that and I love it. I enjoy what I do.
Well, tell us about that. It's an 8-week cooperative parenting.
Yeah, I haven't worked on that for so many years, but let me tell you, I loved it. So cooperative parenting is a program where when parents are in conflict, they don't understand what they're doing to their kids. And so they may say something like, "What happened in court today? Like, you're such an idiot. You hurt the kids. You do this. You're such a terrible dad." And back and forth. And who gets caught in the middle is the kids. And the kids suffer tremendously because sometimes you have, somebody who's observing their dad and they're thinking, "My dad's a good guy. Like, my dad's good to me and he's kind to me." And then mom's bashing him and he starts thinking, "Well, I can't trust my judgment because he seems okay to me." And so they often develop some real significant mental health issues. And so I talk to the parents about how can you reduce conflict? How can you create a stable environment for your kids? What can you do? Kids need at least one stable parent who's mentally stable. And so we talked a lot about that. And the program just kind of went through the legal process, the family courts, what you do when you're in your family court and you have somebody who's taking you back constantly, how to reduce that conflict. So I was really passionate about that. Did it for many, many years.
Is that a paid course?
It is. It was a paid course. I tried to get a couple of grants, but they were really hard to come by. We also wanted to do a sliding scale, but the university didn't offer that.
How much is that course?
Gosh, I don't know what it is now. I think it was like $149, but
$299.
Is it $299 now? I don't remember what it was, but it was a course that, gosh, I haven't been involved with it since 2013, I think. But at the time, I don't know what they're charging now.
Were you hired by UNLV to do that?
Not to do cooperative parenting. I worked at UNLV for many years as teaching in the paralegal program. So I worked in the educational outreach, and I worked in the paralegal program, and I taught basically individuals like how the legal system works. And then from there, I learned that there was this need really to kind of help these parents understand the conflict and what they were doing and what they could do better. So I loved it.
Were you doing that course while you were a hearing master?
No. Before I became a hearing master for a little while, I ran the drug, alcohol, mental health courts for the county. Okay. So I did that, and all of those, at that time when you work for the county in management, you don't hold outside positions. So I relinquished all my outside positions, and I worked just for the court from that point on.
You weren't getting any salary from UNLV?
Well, I got it. I was on a contract with UNLV many years ago. Yes.
And how did the students get to go to this course? So the courts tell them to go to the
sometimes the courts would tell them to go. Oftentimes their attorneys would, because they were frequent flyers, or their partner was a frequent flyer. Often I wouldn't call them vexatious litigants, but they were back in the court a lot, and they were mired in that system, and it was very stressful for those families and for the kids.
Okay.
Is that part of their case plan?
No,
okay.
Because that was the domestic side of the house. So we have the dependency side of the house, the domestic side of the house, the juvenile side of the house. And that was part of the domestic side of the house. So not part of the CCFS case plan.
Okay.
In 2009, the Las Vegas Review-Journal did a story on that. Were you aware of that story?
I don't recall. 2009? Yeah, I don't know. I don't remember.
Let's talk a little bit about court observers.
Sure.
Do you allow court observers in your court?
Absolutely. I work in a largely dependency caseload, but I also have a domestic caseload. So certain hearings are closed by statute in dependency. Adjudicatory, termination of parental rights are closed, but absolutely, when you come into a review hearing or we're at a dispositional hearing, I think it's great to have people observe the court. I mean, that's how I learned how to act in court. That's how I learned how to practice before a judge, is I would sit there and I would watch that judge, and I would learn what their practices are, how they did things, how attorneys appeared before them. And I learned a lot from that process. I think people should do it more.
So you've been on the bench for how long now?
10 years.
10 years. That includes
hearing master, right? Being a hearing master.
And what is the feedback, if any, do you hear from litigants and attorneys that appear before you?
What kind? You mean feedback in terms of my performance,
yes.
or feedback?
The performance.
Maybe I only hear positive things, but I hear a lot from the community that I work with adoptions. I hear a lot from the parents community, the parents attorneys. So I hear positive feedback. I don't know if that's because the negative feedback is hidden somewhere, but we'll see. I don't know. Maybe it's out there. So.
Okay. Ms. Phillips.
How often are you asked to recuse off of the case from one side or the other?
I don't actually think I've ever been asked to recuse. I have recused myself. So when I had a case many years ago in a juvenile sex offense case and I knew the parents, I would recuse, and I had somebody else take it over. I had another case where I knew foster parents, so I recused. So if I feel like there's any conflict of interest, I always disclose and recuse. But I've not had anybody that I know of take me off the bench or for a case.
Have you ever told an attorney, we hear all kinds of stuff?
I'm sure you do, absolutely. And I hear it from Keith. I mean, that's the benefit of mine, because, he's practicing. So I hear he comes home and he's like, you wouldn't believe what happened today. So I get to hear it. So that's good. I get to hear both sides.
You've never said to an attorney that if you get this case in front of another judge, I'm going to go talk to that judge and get this case back in my courtroom.
I would never do that. The only time that could happen is like, say I have a family friend who's doing an adoption and we're at that final stage. I might say to the judge, hey, this is a family friend. I'd like to do the finalized adoption. But I don't do any of the TPR cases. I'm not involved in anything other than an adoption. But I wouldn't take a case from another judge under those circumstances. We're assigned. If I have history with a case, one family, one judge would require that I take that case. But in terms of asking for a case other than maybe an adoption where I know the family and they have gone to the other judge and say, can Judge Pickard wrap the gavel to finalize? No. We don't talk about cases with each other. That would be unethical.
Okay. So the TPRs, you do those, right?
Yes. Well, there are two kinds, and
Okay.
I do both, but I don't usually do them in the domestic arena because there's usually not a basis. So
how often do you do those, and what threshold because it has to be very extreme in order to terminate a parent's rights? I mean, that is, are you a parent?
It's a civil death penalty, yes.
Are you your
7 kids?
Okay, so you
Seven.
know
Wow.
how devastating, that is. So
Of
what
course.
does that threshold look like?
Well, so there's a domestic side, right? So like a parent will come in and say, I want dad's rights terminated, right? I had a case recently. I want dad's rights terminated. I'm like, so tell me about that. And there's absolutely no basis, right? That dad got mad at the kid one time. But if you go into a dependency case, that federal law requires that the child have some kind of a permanency goal within a year. So we usually give the parent a year. If they're on their 5th, 6th, or 7th termination of parental rights, the time shortens under motion to waive reasonable efforts. But other than that, usually if you've had the case open for a year or two, the parents haven't achieved sobriety, they haven't achieved housing and stability, they haven't achieved mental health stability. That's when you start looking at those issues. But if they're making progress, the state on its own usually will say, we're going to give this parent more time to get their kiddo back, because the initial goal is always reunification for the parents.
Well, sometimes if they're having employment challenges, or they're, they just don't have money, or, and their living situation is, that's not a reason to take a parent's rights away, right?
And that's why Department of Family Services has what we call a GAP program. Let's say that a family has temporary issues with housing, right? So they might offer them GAP housing, a period of 90 days, or even sometimes more. I've seen them do 6 months or a year, where they give them GAP housing until that parent can get on the program that they qualify for or get housing. And remember, by the time the Department of Family Services is involved, unless it's an exigent circumstance, an emergency, they've often worked with that family multiple times. So like when I come see a case, I might see 9 prior investigations, none of which the kids have been removed. They've tried to get the family services. They've tried to get them housing. They often pay, it's very common, you'll hear they paid for a hotel, the Roadway Inn, the La Quinta. They're part of that GAP housing program. So we should never remove for resources. Resources are often a symptom of something deeper, a drug addiction, a mental health issue, right? So, but if it's an employment issue and the parent's stable and they can provide them GAP housing, they're going to do that until that parent can stabilize.
So you would remove those rights to somebody who is consistently testing positive for drugs, right?
Well, not necessarily, right?
Oh.
So let's say that a parent is consistently testing positive for methamphetamines, for cocaine, and it's affecting their parental capacity, right? So there's differences. So if it's marijuana and their levels are within a reasonable limit, it's just, we treat marijuana like alcohol, right?
Yeah.
We're not going to be able to give a parent a newborn if they're actively using alcohol and they can't take care of that child, or marijuana. So if it's affecting their parental capacity, yes. So if they're testing positive at high levels, if they're not coming down, they're not in the treatment program, they haven't gone through detox. But by the time we get to a termination of parental rights case, they have been offered multiple times to go to detox, to go to programs. The department, I will say, go pick them up and drive them to a detox program. I did that last week. I said, you need to be here. It's 2 blocks away from where you live. They'll come, they'll drive you to a detox program. So there's no barriers.
Do you think that one person should make that decision to terminate parental rights? Because I've been advocating for a tribunal or a jury, because I don't think one person should be able to change the course of somebody's life or whole family's life forever. I think it should be a tribunal or a jury. What is your feed on that?
Well, I think it's interesting. So that's one of the reasons why the legislature changed the law, so that a hearing master didn't terminate parental rights. So that judges had to do that. And in a way, we have a review panel in the appellate court, right? If we terminate, well, there's always, if you terminate a parent's rights, there's always a paragraph that says, you have the right to appeal this decision. It is a mandatory part of any termination of parental rights. It doesn't. If they are appointed counsel, so if you're qualified for appointed counsel, you have an appointed counsel to take you through the appellate process. And so that's a great opportunity for them. They can come in, if they file informa pauperis, which means they can't afford attorneys. And the threshold's pretty liberal. They can get an attorney to do the entire appeal for them. They can get a waiver on the court record for the appellate court. So they can take a look at that. And remember, so by the time we get to a TPR, the Department of Family Services has made a recommendation. The district attorney's office has looked at that. And as a judge, if there's any chance that parent is going to make some improvements to be stable, we're going to give that to them. But if they're older, oftentimes a guardianship will be set up with a family member to keep them in a guardianship till mom and dad stabilize. And I'll tell the parent, look, when you get stable, you come back. And you come back and I'll have the department confirm that you've got housing and you've got yourself clean and they've gotten some program. And then let's talk about getting that dissolved so you can get your kids back into care. And that's a reasonable alternative.
The child is adopted out.
Well, they won't be if they're older and they have a family member. So let's say you have a family member like grandma, grandpa, aunts, uncles, or fictive kin, somebody who the child has a relationship with. If they're older, they're usually going to do guardianship. If they're over, they have to consent to do an adoption, right?
What's
if they're
older?
over 14.
What's
over
that age?
14.
Okay.
They have to consent to an adoption. But sometimes even if you get a 12-year-old and maybe you have a sibling who's 6, then they'll still do a guardianship. If it's reasonably likely that within a predictable amount of time the parent's going to be able to achieve stability, the department's more likely to do a guardianship. And I think those are good. And this is why, because I'm a grandparent. I love my grandkids, but I don't necessarily want to raise my grandkids. And a lot of grandparents don't necessarily want to raise their grandkids, but they're willing to take care of them while mom and dad stabilize. Mm-hmm. So that's a great option for a lot of these families. So aunts, uncles, right? So if you do a guardianship with an aunt and say a grandparent, which you can do now, it's great because if grandma and grandpa pass, then you've got another family member. And it's got to be within a reasonable time. And so termination is really the last possible realm that we look at. So if you have a safe haven baby, somebody who was abandoned at birth, if you have a newborn and you have a parent who's been addicted for years and they haven't made changes, they've come through the system, they've had 4 or 5 prior cases, they are going to look at termination. If you have a newborn who the parents, and I have this, they say, I don't want this child, or I can't care for my child. And so it's amazing how many parents are often offered the opportunity to do a relinquishment, and that changes their course. So if your rights are terminated involuntarily, that changes what happens if you have kids in the future. If you relinquish, you kind of have a clean slate for if you have kids in the future as well. And so the question is, at what point of time after we give that? I look at it this way.
That's not a good choice.
Well, the first year is all about the parents' rights for the most part, right? Like we're trying to prioritize the rights of those parents. What can we do, or what can the Department of Family Services do to try to reunite that family? That's really what we're looking at.
What do some of these parents complete their case plans? They might have tested positive for drugs, in the beginning. They got cleaned up. They went to their counseling. They did their stuff, but yet still have their parental rights terminated. How does that even happen?
That would be very rare. There are times where, say, somebody says that, I finished my case plan. I mean, first of all, I want proof that they finished their case plan and engaged. And it's not just about finishing their case plan. It's about making behavioral changes. So let's say that they say, I've got a case plan and it requires me to go to domestic violence services, right? Because I was either a victim or I was the aggressor repeatedly. Well, they say, 5 years ago, I took a domestic violence class, but they committed domestic violence last year and then maybe 6 months ago. They probably need to be reevaluated, right? And so when they say they complete their case plan, my question is, when did you complete it and what services did you engage in? But I would be very unlikely that I would ever terminate a parent's rights who completed their case plan and made a good faith effort, because there's no reason to. If that parent can stabilize and healthfully and safely parent their child, they have the right to have their child back in their care.
How often do you file or sign TPRs?
I sign TPRs on a regular basis, but I also have a caseload of 500 cases. And so There's about 20,000 calls were made into the CPS hotline to date for 2025. And so on average, we see about 2,000 of those actually come into the legal system. And if we have a termination of parental rights, again, usually that's a year or sometimes 2 years down the road before they ever go to termination of parental rights. And usually by the time we go to termination, we have a parent who isn't showing up, hasn't visited. Maybe there's a presumption of abandonment. They've had no contact with that child for 6 months. If they're usually actively engaged in their addiction, they usually have some significant mental health issues that haven't been addressed. So it would be rare. I'm not saying it never happens, but it would be rare if somebody completed their case plans with proof of services that their rights are then terminated.
That should never happen.
Right.
Not even one time should
Well,
that happen.
Again, I don't know when they say they've completed their case
Right.
plan. What does that mean time-wise? They also, this is the other thing a lot of parents do. They say, oh, I went to this counselor online and they saw them once and they said, I'm fine, right? But is it an approved counselor? Are they a licensed counselor? Are they able to assess this, right? So in terms of, I've never had one where I can say you've done everything you're supposed to do and you've made all the changes and I'm not giving you your kiddo back. I would never want to do that to a parent. I am a parent. I don't want my rights terminated.
So back to my original question, do you think one judge should make a determination to?
I wouldn't be opposed to the idea of a tribunal. I don't know how that would work. I really haven't thought about it. Well, I realize that. So really, that's why we have the appellate court, right? So if the district court is making a mistake, but when I write a decision, I don't let anybody else write my decisions. If I have an evidentiary hearing, we go to the evidentiary hearing. I write a very extensive decision on why I've made that choice and why I'm following the law. And the law lays it out very clearly. They have to show that if they've been out of the home for 14 or 20 months, they have to talk about what services they've participated in. Have they abandoned a child with no contact for 6 months or more? Are they unfit? Have they been neglectful? How serious was the harm that was inflicted in the first place? But it's never that goal that we start with, ever the goal that we start with.
Do you ever follow social media of your litigants?
Never.
You never see what that is.
The only reason I would see it is if it was brought in as evidence by one of the attorneys and they wanted me to look at something. So, for example, the district attorney may try to introduce something into evidence during the trial that a litigant has threatened to kill somebody, or they're stalking the foster family and they're threatening. But that's usually the only time we see them. But I would never actively go out and search for a litigant's social media.
So you've never told an attorney to have one of their clients remove social media posts?
Yes, I have actually.
Now,
I've had a case.
Happen?
I had an individual who was threatening harm to the foster family and posting their addresses and posting information that put the kids at risk. And I did say, you need to remove those posts. Those are unsafe for the children. Why would you put a kiddo's address in the public forum? Because somebody then could find that child. I mean, there's a lot of people out there that are not safe. So in those instances, I think that the one time that I did, because they put that kiddo at risk.
Have you ever awarded custody of children to a parent who has tested positive and convicted of drug dealing, abusive, anything like that?
Have I awarded custody when they're under active addiction or in recovery?
Yeah, they test positive for drugs. They have sold drugs, been convicted of it, been on a sex registry as a tier 2 offender, abusive, and this is with the coercion of a minor under 14. Have you ever awarded custody to somebody with that type of background and record?
I've dealt with so many cases. I would say, in general, if somebody's in their active addiction, then we wouldn't cut the child with them. We would put them on supervised visit. If you have somebody who is a tier 2 offender but no longer on the registry and they have rehabilitated, so to speak, and how long ago was it? Was it 10 years? Was it 20 years?
How about 1 year?
Not likely for 1 year that I would ever do that. For 1 year? I mean, a person was 1 year ago on the sex registry and then released. I don't believe that I would normally do that if I have that information in front of me, in terms of I would never put a kiddo at risk intentionally. Or, I mean, I think I do a pretty good job of evaluating the backgrounds of the individuals. Can it happen? Yeah. And here's part of the problem.
How does that happen?
Because
if you know their background,
we wouldn't, if
history.
I know their background in criminal history and I think that there's a risk factor, I would not. The big issue is this: under the current law, if you have a kiddo who is removed from a parent's care, and let's say it's mom, the kiddo's lived with mom for many years, right? And dad's been kind of out of the picture. But at the time of removal, they find dad in another state. And they say that the dad's safe. We've done a background check. He seems to be safe. He seems to have a stable home. We've had Child Protective Services there go out and check the home, and it seems safe. They might put that kiddo with that parent, but it should come up on the background check that there's a problem. And I can't even imagine the department even making a recommendation for a child to go into a home where a parent was on the registry that recently. So, but my concern is that now, if I've got a safe parent out of state, I have to put that kiddo with that parent who they don't even necessarily know. That's kind of scary for a kiddo, right? But they have a parent right. And maybe they don't have a relationship because maybe mom blocked it for many years. I don't know. And I need to find out. And that's why we have children's attorneys that help those kids.
But if you have another choice, you have a parent with being abusive, drugs, all that, DUI, on the registry recently, but you have a perfectly good family member who those kids could go to. How do you make that choice?
Well, if they're actively in their addiction, that's from what you're asking me, right? Like they've recently tested. And again, recently means the last 90 days to 6 months that they've tested positive. Again, what drugs are we talking about? We're talking about methamphetamine, cocaine. Yeah. Well, street drugs, marijuana drugs that are
minus the legal ones. Yeah, right. Which is marijuana.
Right. So again, how stable are they? Do they have housing? Do they have work? But still, if they're on the registry, if they've recently had a domestic violence incident, or they have a conviction for it, it's not likely that they're going to be considered to be a safe parent at that time without some additional services.
So 90 days, somebody is clean. That gives them a pass to have their kids back. Only 90 days.
No, not necessarily. So 90 days, let's say, like I said, 90 days to 6 months minimum of their sobriety. Here's what happens is parents come in and they go, I know he tested positive when my child was born for methamphetamines at 50,000. And when I tested positive, I haven't used now in 3 weeks. Okay, well, you need help. You need services before you get your newborn back in your care. And so it's not likely. And I say to them, you need to be clean at least 90 days to 6 months with consistently clean drug tests in order for the department to look at the placement of your child. But again, there's so many extenuating factors. But that's usually what I'm looking for is some kind of level of sobriety. Again, I don't know what they're using. If they're using marijuana extremely high levels and they're not functional, and there's a history of difficulty with what we call parenting capacity, it's not likely they're going to go back immediately. And again, a lot of people are buying marijuana on the street right now. And that is laced with fentanyl. It's laced with methamphetamines, not mostly fentanyl, but methamphetamines. So they're coming in and they're testing and they're saying, well, I only bought it on the street. But you can't because it's not regulated. And so again, they're testing positive, and that's a factor that we look at. And it's always about the safety and security for the child. That's always what we're looking for. And if we can save, and I tell every parent this, the goal is to reunify. When you first come in, the goal is to reunify. The question is, how quickly can that happen is based on you and your participation and your openness with the department. Are you hiding your abuser in your house? You know how many times an abuser is found in the closet of the victim? And they say, oh, I'm not seeing them, but they're found, right? They're found by police during a raid or something. Or there's been a recent raid on the house. So there's a lot of different factors that we take into account. But again, it's always the safety and the security of the child.
How often do you have, I imagine children come in and meet with you in chambers. And
I never even child in chambers.
when do you meet with them if they have to tell you they're being abused, or they tell you, I want to live with this parent or that parent, or I don't want to be with this one, or they tell you what's going on?
So there's different
How does that
categories. So
happen?
if I'm in a domestic case, like a child custody case, and the parents want me to interview a child and both of them consent, I absolutely bring that kiddo in. It's always on the record. Parents have a right to watch me interview their child, and you'd be amazed what parents learn when we're talking to that child. In a dependency case, they're represented by an attorney. And if the attorney, a CAP attorney, wants me to speak to that child, I absolutely will bring that child in. And I regularly interview them in the courtroom. Their parents can be watching virtually with their cameras off. The child has a right to have their attorney present, but the parents have a right to hear what their kiddo is saying, right? I don't believe anything should happen in chambers where it's closed. They have a right to watch. They have a right to know what they're being accused of or what people are saying. And it's always on the record. I do everything on the record. I don't even do sidebars in the hallway. I do sidebars on the record in my courtroom. So you all know what we talked about, and there's no side deals anywhere. And I learned that long ago.
I want to play something for you.
Sure.
Maybe you've heard stuff like this before.
You want to put it to your mic.
Okay.
That goes on for 4 minutes in the house. How, when you hear things like that, what goes through your mind? You're a mom. I can hardly even, that makes me shake inside.
Sure.
It infuriates me.
Sure.
And knowing that children are in a situation, in a household like that, how do you listen to stuff like that and allow children to be in that situation?
So hopefully by the time I were to ever hear that, the Department of Family Services has intervened and investigated and determined why that was happening. Hopefully somebody's reported it. Things don't get reported during the summer. Schools are one of the best reporters, right? So we need to know about it. But that needs to be investigated. That kiddo, every kiddo has the right to live in a safe home free of violence. And I say that all the time.
That's not just a normal spanking.
No, not at all.
To me, and to hear as long as that went on, like usually if you spank a kid, they're off
Right,
in a minute or two,
right,
and they're off playing with something else, and away they go. That to me is extremely aggressive, abusive, and I can't imagine any judge allowing children to be in the custody of a parent like that.
Well, and again, hopefully Clark County Family Services has been notified. They've investigated. If I heard that in a domestic case, I would absolutely call the hotline myself and say, I'm concerned about this. You need to investigate this. That's exactly why CCFS exists, often known as CPS on the front end.
Yeah, they need some improvements. Those people that agency is terrible. I've already asked you all of that. Are you running for re-election? You are, right?
I am running for re-election, yes.
Will you clear up something for us?
Sure.
I have read these articles and people have sent us stuff. Tell everybody about that Truth in Posting company.
Absolutely.
And the Cheaterville and all of that stuff where you remove these posts that cheaterville.com had on there, and then all the lawsuits. Will you just clear that up for once?
Absolutely. So many years ago, I owned a company called Truth in Posting. And I owned Truth in Posting, probably 2011.
What does that company do?
Truth in Posting was exactly what it says. If somebody accuses you of being a pedophile, okay, and they post it online, you have a right to challenge that. But most websites don't have any process to allow people to challenge what's posted about them. So Truth in Posting was essentially an arbitration company. And they would say, if you're going to call me a pedophile, my company would come in just like you were in a courtroom and say, prove it. What documentation do you have to prove that Steve Sanson is a pedophile? Where's your documentation? Where's your court conviction? Well, it is, right? Because it's defamatory. Exactly. It is defamation.
And that's an aspect.
But you have a right. But you have a right. Do you know how hard it is?
She can't condone that.
You know how hard it is to challenge it in federal court? Most people have no resources to do that. So let's say that you're a business person, you're a dentist, and somebody accuses you of being a pedophile. What's that going to do to your business, right? So you have a right, and this is what I did in Truth in Posting, was to work with different companies, Cheaterville was one of them, to say, if you're going to put something up, you better back it up. So it's exactly what it says, Truth in Posting. And it is absolutely, now there was an individual that I removed their posting and he got really pissed. And what's so interesting is he posted something, I don't remember what it was, some pornography or revenge pornography. And my company said, prove it. I don't remember what the allegation was. He didn't respond. We, by default, removed his posting. And he just had it out for me for several years. He's since been killed, unfortunately, I found out, from federal agents who were very much protecting what was going on. They were investigating, federal agents who were investigating for a lot of things. And they filed a lot of lawsuits, like with very vexatious litigant. I was involved in one lawsuit in Texas. I got dismissed immediately because the judge clearly saw what my company did. But otherwise, it's a great company. There should be more companies like that don't allow people to just post whatever they want on the internet about us, about you, and damage our reputations. You're a professional. You have a right to have somebody back up what they're going to say about you.
But people say that you were friends with, I forget the guy's name, Gibney, the guy who started Cheaterville.com. James Gibney. Because they started both within a month of each other, apparently. Your company and Cheaterville.com. Is that true?
No, Cheaterville was on. Cheaterville had been on for a while.
What is Cheaterville?
Cheaterville was a company that James Gibney was a veteran. While he was in the service overseas, he had, I think it was a friend of his friend's wife or somebody was cheating. And he was basically saying, if you're dating somebody, you should have a site where people can out you for that. And so Cheaterville was one of the companies I worked with. I worked for a lot of companies, right? So I worked for a lot of different companies. They're just one company. But yeah, they had a lot of defamatory postings put up. And my company would say, essentially, prove it.
But you guys weren't friends. You weren't.
I never socialized with him. I never went to dinner with him. He was on a radio show that Judge Rochely and I had. Mm-hmm. And when we were talking about these things, he asked me, because he knew I was an arbitrator, if I would contract with his company. So I contracted with multiple websites. He was just one of the websites that I contracted with. But everybody has a right. You have a right to have arbitration when somebody's going to post something about you. At the time I was teaching at the university, if somebody had posted something about me being a convicted felon, I could lose my job. So you're going to post it, prove it. That's exactly what Truth in Posting was. You have to have truth in the postings you put online about individuals and to not damage their reputations.
And I saw that in your bio about the radio show. What was that about?
So Judge Rochely and I, we weren't judges at the time. I worked for Stacy Rochely and Rock Rochely for about a year, and I did arbitration and mediation. And so I just basically rented space in their office and I did arbitrations and mediations. And then through that, we started Divorce War Radio because a lot of people in the community, they don't have anybody answer their questions. How do we work the family court system? It's overwhelming. When I was practicing law, I was a child's attorney, cap attorney for a pro bono. And I was so frustrated because my kids there was something going on and they wanted to tell the judge because that's the only way I can talk to the judge. I couldn't even get the hearing on in front of the judge to tell the judge. And I was like complaining to everybody. And it's frustrating. And I still get frustrated when you have a filing in family court and your trial is put off for 9 months and you're talking about custody. That's a problem, right? So we need to have an efficient system. The family court is set up for very adversarial, and it shouldn't be. When we're dealing with families, we should have more of a mediation and arbitration system so we can get this for child custody. And I also oversee the UNLV mediation program. And that's a program run by UNLV where families, whether it's property, it's mostly property, they can go in with mediation and kind of work it out, especially when they're not represented. Okay. We have to have access to justice.
Are you one of those judges that when he came rolling into family court one time and a bunch of doors were locked, were you one of those that had to lock doors?
I don't think so. My marshal knows not to lock the door.
Because everyone said when we see family court judges, they're like, hey, we keep our doors unlocked.
We do. So we do keep, I mean, if I'm in court,
lock yours?
We don't ever lock the door if we're in session.
Okay.
If I'm not in session and I'm prepping for the next day, it would be locked. But we don't keep it locked otherwise. We know, I mean, my marshal's here. He knows we don't lock the door and we need to have it open. So if I'm in an adjudicatory trial, and that's the plea hearing portion, or a TPR trial, you had an observer come in one time and I said, hey, we're actually in an adjudicatory. Can you come back this afternoon and you can sit through all of our hearings and they'll be open. And so I've welcomed him back. So I think that there's nothing wrong. That's how you learn about your court system.
I like to piggyback on what you just said because I've heard through several marshals and judges that when I come to family court, they get on their walkie-talkie and announce that I'm there. Do you know why that is?
I don't know that that's happening. I'm not familiar with that at all. They shouldn't do that, right? You're a member of the public. You have a right to come into the courtroom. And again, that's how we learn about the court system and what's happening.
Have you ever heard of anything like that?
Them locking the doors?
No, announcing that veterans in politics.
I have not. I mean, I'd be surprised by that. I think that
I was surprised when I first heard it, but then I kept on hearing it from several different people.
Yeah.
So then it became real.
I have not.
She even heard it one time too.
We know that's true because the judges will text him and say, "Come up and see me when you know you're in the building."
Really?
Yes. Really.
Yeah.
Well, if that happens, you have to tell me so I know.
He's got a walkie. You should know.
Yeah. So not that I've heard and not that anybody's told me. No, not at all. I mean, really, right, since Falcone came up and, and the Senate bill, I mean, one of the big issues is we need to 100% open our courtrooms up every time we can, right? Under only very limited circumstances should cases ever be sealed, especially in domestic cases. And that's how we learn. I love watching.
Do you believe it should be a felony for a litigant to talk about their own family court case?
It should not be a felony for litigants to talk about their own family court case. But here's the difference, right? So like, let's say I'm talking about it with my family and my friends. If I'm posting a rant on social media, I should have a First Amendment right to post that rant, right? You pissed me off as a judge, or you did this, and this is what my ex did. I mean, they have a First Amendment right to post a lot of that information, right? So no, it shouldn't be a felony. I don't make the laws, though. I enforce the laws. So I have to be careful of expressing my opinion. But generally speaking, people should have a First Amendment right to express their frustrations, whether that's with the court system, the law enforcement, whoever it is, right?
So October 1 now, you'll be charged with, and this affects a lot of what we do. We advocate for family court litigants. We're over there frequently. Sure. And sometimes you have to come out in the public and call these people out for making terrible decisions, giving kids to abusers, terminating parental rights when they shouldn't have been, corruption. I mean, the list goes on. And without the litigant's ability to come on and say, son, after October 1st, this is going to change on sealed portions or sealed cases, as you know, and that, to me, it's a violation of the First Amendment. And that will severely affect how we talk about the litigants that come to us and what we say, and how we're able to advocate for them. I hope that is somehow reversed, or they do something about that law.
Yeah, I don't know how it's going to be met by the Supreme Court and the Supreme Court's oversight. But the Supreme Court has been very clear. These courts need to be open. Right?
How often do you seal cases? And do you make that decision to seal?
I don't seal
or is
cases.
It the party, the
dependency cases tend to be are sealed for adjudicatory intermination. So 2 stages of that process. Domestic cases, I haven't sealed a case. I don't think I've ever sealed a case. Early on, before we had the Falcone decision, if the party stipulated to do it or one party wanted it, it could be sealed. But since the Falcone decision, we don't do that. I will say I did have, when I was the juvenile sex offense, I would ask if we had observers that came in and there was an extremely egregious situation, sometimes the attorneys would ask that the courtroom be closed while a child was sentenced, and I would usually grant those for the best interest of the child because children make stupid decisions, and it shouldn't follow them forever.
Do you have secret Zoom meetings with anybody?
A secret Zoom meeting.
Attorneys,
Look, nobody in the courtroom that walks into my courtroom is my friend. I tell parents that all the time. I don't socialize with the attorneys that come into my courtroom. I don't like their Facebook posts. They try to get to be friends with me. I mean, I also have to balance that I'm a politician, but I never have a personal relationship with any attorneys that come into my courtroom. I'm very careful about that. I don't socialize with the legal community other than if I'm at a function like a gala and I see people and I'm like, how are you doing? Right? But I don't go out to lunch with you. I don't, have a party with you. We're not having birthday parties with our kids together. I need to be arm's length from any litigant that walks into the courtroom and their attorney.
Do you close hearings? Because I remember when I showed up with my observers in different courtrooms and you have the respondent and the other parties there and with their attorneys. And I'm in the back, minding my own business, just watching. Like I told Mark Denton, I'm in your courtroom to watch you, And they turn around, and they see me. Judge, I'd like to close the hearing.
Well, I think you can do that after Falcone. I don't think you can do that, right?
They shouldn't be able to do that at all because they're supposed to file a motion ahead of time.
They should have a motion hearing, but
not now, right now, we're going to close the hearing just because I'm in there.
Well, and you have to find a compelling reason, right? There has to be a compelling interest to close that hearing now, right? And so those are the things that we have to look at. Nobody should, especially after the Falcone decision, should be just closing the courtroom because one party moves forward. I mean, the statute was written differently, right? And now we have the new law coming into effect October 1st. So that's going to be different. We're going to have to see how that falls out. But I'm always cautious to close hearings. I mean, I grew up in my early legal career in Montana, where we sat through every single hearing that the judge had. We had a general jurisdiction judge. We would sit in the back of the courtroom. The idea that the marshal would come out and get us in the hallway, that never happened. If you weren't there and you weren't in the courtroom when your case was called, you were skipped over. And then you hope that they called you again later. So we just sat through everybody's hearings, and that's how you learn to practice law. It was a good experience, and the public should do that too. I tell people all the time, you can log into our courtrooms, appear virtually. You can even put, my marshal always asks who you are, but you have a right to be in there for most of our hearings.
We'll be in your courtroom soon.
You can, absolutely. Adjudicatory appeals are sealed, but other than that, 100%. And I told your observers when they've come in, when they have come in, that those are the only limitations. But come in anytime. And virtual is fine too. I very much believe in a hybrid courtroom, especially with the clients or the parties that we deal with. They can't always take the bus for an hour and a half with 3 bus changes, right? But they have a right to be in court. So absolutely. Come in.
We will.
Okay. Call our department and we'll get you the link.
Ms. Phillips, do you have anything else for Judge Pickard?
That's it. Otherwise, we'd be here all night. I don't know what time it is.
Oh,
I had a
8 o'clock. Okay.
Judge Pickard, do you have anything else that we have not mentioned, something you want to put on the record?
I don't think there's anything. I mean, I really believe that we have to elect judges who are knowledgeable about these subject matters, that have background, that have history, that can do the job. I think we have 100% the temperament.
Constitutional judge.
Yeah.
Have you ever yelled in court or yelled at attorneys or anything? Because we see some of that going on.
I will say one time I was very upset because a child was improperly sent to California, depriving me of jurisdiction. And I was mad. I was very
I'm sure that
angry.
pissed you off.
He'll tell you, I slammed my hand and I said, this is outrageous. I want your supervisor on in the next 30 minutes to justify what happened. I ordered that child remain here with family. I was furious, but I don't yell. I'm very careful. When I was appointed by Judge Barker the first time as a hearing master, he said, everything you say can and will be held against you in a court of law. And that's true. And I do everything on the record. Like, that's why I had no background.
Judge Barker. And you were doing family?
At the time, I was a hearing master under Judge Barker, but I actually run the drug, alcohol, and
You're
mental
doing
health courts.
civil criminal?
No. When I worked for Judge Barker, I was doing the drug, alcohol, and mental health courts. I was overseeing those courts at the RJC, and I did that. And then from there, I was appointed as a juvenile hearing master. No, he's not, but he was the chief judge at the time. He was the chief. So, but he's right? So, and everything should be on the record. I mean, I will tell you, every parent that comes in, I treat them with respect. You have an individual litigant comes in, I call him sir, I call her ma'am. Like,
You
give
called
me
them
that.
mental?
I never call them mental.
Nobody's
That's
mentally.
completely rude.
You're-
Like, I think that people who have mental health issues, they don't know it and they don't accept it usually, right? So I will never rile them up. One thing that I hope you observe when you come into the courtroom is that I'm always respectful. I mean, they're going to treat me, they're going to call me ma'am. I'm going to call them ma'am. I'm going to call them sir, right? They deserve that. I will be respectful to them. There are times when I'll say, you've had your time to speak. Now they're going to speak. So we're going to mute you for a few minutes because you won't stop talking. So we're going to let them speak. But that's courtroom control. But everybody deserves respect. Even the person who, is coming in and is just facing the tribunal for the first time, right? But at a certain point, I do have to cut them off.
One of our listeners said you terminated their parental rights yesterday.
I may have. It's possible. I terminated a couple of parental rights yesterday. And I probably can tell you who that is.
Well, Judge Pickard, Mark is going to zoom in on you.
Absolutely.
And you could have the final say. Come vote for me, come visit me in my courtroom, or whatever you want to say.
Sure. So thank you for having me on. My name is
Absolutely.
Margaret Pickard, and I am a family court judge in Department B. I am here to serve the public, and I tell my entire staff that we are public servants. We are here to serve you. Our offices are always open 8 to 5. We're at the courthouse. I have no admin days, 0. I don't even have an admin afternoon.
You work Fridays?
I work Fridays.
You pack?
I have no, what do you mean? Do I pack? I do not have a CCW. My husband has an artillery, but I do not.
Chief has an artillery.
Oh, yeah.
Really?
Yeah, he used to be a 3-gun competition guy. But I will tell you, I am all about us making sure that people's constitutional rights are protected. I'm all about making sure the children's best interests of the children are always protected. And I invite anybody into my courtroom at any time to come and watch and to ask questions. In fact, I often have observers, and I always try to say at the end, do you have any questions about what happened? Do you have any questions about the process? I have flyers in my courtroom about the process. So I'm all about, let's educate people about what we do and why we do it. But I do work 5 days a week. I don't have admin days. I am very cautious. Even when I'm on vacation, I'm still signing orders. We also are on warrant duty. And I don't think people realize this as a dependency judge. Every 6 weeks, I'm on warrant duty for 2 solid weeks. Mm-hmm. I just finished an entire month of warrant duty because I was covering for another judge, which meant my phone was never off, not at 3 o'clock in the morning, not at 2 o'clock in the morning. My phone was always on, and I would always take calls regarding warrants. And that's how kids should be removed, right? Absent exigent circumstances, you should have to have a warrant because that's a huge deal to remove a child from a parent. And if there's any way their present danger plan can be put into effect, it should be. So what I will say is that I absolutely believe I'm a public servant. I tell all of the people on my staff, we are public servants. We are going to answer our phone. We are going to return a phone call that same day. We are going to be very diligent in getting our orders out. I have no orders over 3 weeks after an evidentiary hearing that are not out and posted, given to the parties. I even ask my staff, email the party so they don't have to wait for a written copy of it in the mail. That might take 3 weeks. Let them know right away what I've done so they have updates on that. If you need a link to the courtroom, call my courtroom, my JEA, she'll give you that. And as you can see, I've got a lot of my staff here tonight. We're friends, we're family. We work hard. We treat everybody with respect, but we are here to serve the community. And I absolutely believe that. So
Judge Pickard, thank you for coming on.
thanks for having me. I appreciate
Thank you
it.
for answering all the questions.
Absolutely.
We really appreciate that. We wish more judges would be able to do that.
Well, I'm happy to do that,
Some
and
of
I've
them can't.
encouraged that. We've talked about everybody should be doing more interviews with our community, right? And that's why we
They
need to
more
get out there.
backbone.
Well, we need to get out there, and we need to let other people see what we do, and also know it's a hard job. I mean, I don't think people realize how many nights I'm working till 10 o'clock at night, how long it takes to review all of those reports that are filed. So it's a hard job. I love it. I'm passionate about it.
Yeah.
And I appreciate you guys taking the time to invite me.
Absolutely. Thank you so much.
All right. Thanks, guys.
Thank you, Ms. Phillips. Folks, that's Margaret Pickard, Clark County District Court Judge, Family Division, Department V. We hope that this program was very, very educational and informative for you. And there's more programs like this to come. This is Steve Sanson, Stephanie Phillips with Veterans in Politics. Until next time.